I'm Daniel Findling with Findling Law and thedivorceguy.com. And in this webinar, we're going to do our best to help you understand what is separate property. That is, what property do we divide in a divorce and what property do we not divide? So what is separate property? Separate property is property that is not marital property, which begs the question, what is marital property? I'm going to put a link in the description and also on top of the screen to another webinar just discussing marital property. But for our purposes, marital property is going to be property acquired by reason of the marriage. By reason of the marriage. That's different than during the course of the marriage. What do I mean by that? Well, let's say, for example, that you were inherited money during the course of your marriage. Uncle Joe passed away and you inherited $100,000. For the most part, that inheritance, because of the intent of the donor, Uncle Joe meant to give that money to you, in this example, is going to be considered separate property even though it was acquired during the course of the marriage. It's also important to understand when we talk about classifying marital and separate property that property can have both a marital component and a separate component. A common example would be a 401k. Somebody worked for 10 years before they got married. They were married and working for 10 years, so we're going to take the value of that account of that 401k as of the date of marriage. We're going to call that value separate. The increase in value during the course of the marriage we'll call marital. So this property in this example has both a marital component, that portion of the 401k that was earned during the marriage, and a separate component. And in this example, the value of the 401k that you brought into the marriage. The doctrine of non-evasion of separate property tells us why classification of property as marital or separate is so important. That's because as a general rule, if we classify property, whatever that may be, as separate property, it's not going to be divided in a divorce with a few exceptions. There are two statutory exceptions to the doctrine of non-evasion of separate property. The first is premarital contribution or improvements by a spouse. Say, for example, there's a home owned in the husband's name, and the wife put $25,000 down before they were married to that home. Now, just because that home is in the party's name, we would first say, well, wait a minute, that wasn't by reason of the marriage or during the course of the marriage, so that home is husband's separate property. And the statutory exception says no. The premarital contribution by wife, her putting in that $25,000 even before it was married, the parties were married, and notwithstanding the notion that it's in the husband's name only, would be considered marital property. The second exception is when the estate is otherwise insufficient. If we look at the marital estate and there's nothing but separate property, under certain circumstances, a court may invade the separate property of a spouse so that person would not become a pauper. The legislative intent was that the legislature did not want a party turning to welfare or state assistance when there's a spouse that can contribute. So if the estate only consists of separate property, it's a basis for an invasion claim. Now that we've examined the two statutory exceptions, we also look to case law for more clarification. Now, as a general proposition, we know that property that you own prior to marriage is separate property. What about injury proceeds or malpractice proceeds? Well, gotcha versus gotcha, pun not intended, provides that pain and suffering damages acquired during the course of the marriage are separate property. What about lost income during the marriage? Well, in an injury case or a malpractice case, lost earnings or income would be marital property. The court also wants us to look at how did the parties treat the asset during the marriage? Did they treat the otherwise separate property as marital property? In many instances, in the cases that we put here on the screen, there was a cottage and a home that the parties always utilized as marital property, even though it was academically separate. The court considered marital. So how did the parties treat the asset is also important. Gifted or inherited property, we discussed this earlier, Dart versus Dart and Bowditch versus Bowditch. even though the property was acquired during the marriage, if the intent was that this inheritance just go to one spouse, to their daughter, their son, whatever the case may be, that also will be considered separate property. Let's take a closer look at the classification of property. And in these examples, property acquired during the marriage, that's actually classified as separate property. The first example is Skelly. In Skelly, we had a retention bonus. A retention bonus, for example, is when somebody receives a bonus up front, let's say $50,000, that's forgiven over a period of 5 years to retain the employee. So in year 1, maybe $10,000 forgiven. In year 2, $20,000 is forgiven. But if the employee leaves, they have to repay the bonus. Thus, they're incentivized to remain in employment, a retention bonus. Now, let's say that in the second year of this bonus, the parties are divorcing, and $20,000 of the $50,000 has been forgiven. What about the balance of the $30,000? Skelly says that that $30,000 is separate property because it's based solely on the continued employment of the individual after divorce. Premarital contribution. We've talked about this before. For example, a retirement benefit that you had as of the date of your marriage is generally considered separate property, but the increase in value during the course of the marriage is marital property. Now, the reason I raise this is because it gets even more complicated. Let's say, for example, that you have a certificate of deposit that is worth $10,000, and 10 years later, the parties divorce, and that certificate of deposit is now worth $100,000. Is the increase in value of that certificate of deposit, would it be classified as marital property because it was acquired or increased in value during the course of the marriage, or separate? And the answer is, for the most part, separate property, because there was no work involved with that certificate of deposit. The increase in value was wholly passive. That is, it just sat there in the bank and grew. Now let's change that example to something that is active appreciation. In the 401k example, the continued employment or management of a brokerage account during the course of the marriage is considered work. And then the increase in value is considered active appreciation. Marital property. That is, if it's passive appreciation during the course of the marriage, it's separate property. If the increase in value or the appreciation is a result of active appreciation, then it's marital. One more thing. A liability during the course of the marriage that has no marital purpose is also separate property. Let me give you another example. Your spouse accumulated $50,000 in debt at the casino and you knew nothing about it. In that instance, or perpetuating an affair for their paramour, right? Motels or whatever the case may be, or being online at different sites that you knew nothing about. And as a result, there's a significant debt associated with that. That debt had no marital purpose. And as a result, the debt would travel to the individual that incurred it. Whereas if you accumulated debt, doesn't matter whose credit card, but to take a vacation to Belize. Well, that has a marital purpose. The family went on vacation. But a credit card charge to take your girlfriend or boyfriend out or book a motel while you're married has none and would be separate property. There's one more problem that we have to address in classifying property as either marital or separate, and that is commingling. When parties use marital funds and use those marital funds to pay for otherwise separate property, that's commingling. Let's take this example. Your spouse owned a home prior to marriage, and it had $50,000 in equity. And you continued to pay the mortgage on the home during the course of the marriage, maybe painted rooms and so forth, and you used marital funds. That home is now commingled. But in this example, the value of the home prior to the date of marriage would still be considered separate because it's readily traceable to its separate source. And this can get complicated, and there are dozens of cases on point. Is the property readily traceable to its separate source? Let's take another example. You purchased a home during your marriage, and one spouse put $50,000 down from the sale of their old home into the home, and you pay for it during the marriage. And the question is, now you're getting divorced, does your spouse get $50,000 back, the down payment? And the answer is probably yes, because we can readily trace that this $50,000 went to put the down payment on the home, and it's still there. It's just in a home instead of in the bank. Now, we're going to change a fact. Spouse takes $50,000 from their separate home to purchase a home during the parties' marriage. The parties improve the home, they refinance the home, they pull cash out, they renovate, and they build a garage or a bedroom or whatever the case may be. Is that $50,000 now readily traceable to its separate source? And the answer is probably not, because when you refinanced the money and took out equity, what equity did you take? We don't know. So if property is no longer readily traceable to its separate source, commingling will make it marital. However, commingling alone is not enough. We ask, how did the parties treat the property as well? Is it readily traceable to its separate source? And this type of inquiry can make or break a case to either maximize or minimize the marital estate. The key learning in this video webinar is the classification of marital property and separate property can make a major difference in the outcome of your divorce case. What is it that you're dividing? And the rules are complicated. We've touched on the surface here, but they are complicated. I'm Daniel Findling with Findling Law and thedivorceguy.com. I'm hopeful that I brought some clarity to you about the classification of property as either separate or marital. Now, because it's so complicated, it's inevitable that you may have questions about your situation or the person that you may be worried about. I provided my contact information below. I can also be reached at daniel@thedivorceguy.com. Let it be our privilege to help manage your situation.